I was trying to request a new attorney though.
Oh, ma'am, okay.
They
And
told me I came
with
down to
that
the
in
court
mind, Miss
yesterday.
McGee, it's getting ready to go. This is why I said she had to come in person.
I did come in person. I came the day you
This
told me
is
to come.
why I said she had to come in person.
Welcome back, everyone. Today we're diving into not one, but two Michigan courtroom showdowns, and trust me, both are packed with attitude and legal lessons. First up, Judge Brian Oakley, the man's reputation? Zero tolerance for nonsense. He's the type of judge who can spot a sovereign citizen argument before the defendant even opens their mouth. And right after him, we're jumping over to Judge Lennis Bryant, known for her commanding presence and razor-sharp patience, until someone decides to test it. In the first courtroom, we'll witness Judge Oakley dismantle a defendant who thinks city ordinances don't apply to him. In the second, a young woman's attitude collides head-on with Judge Bryant's courtroom authority. These two clips perfectly capture what happens when defiance meets the law. Stick around, you're about to see two completely different judges handle chaos in very different ways.
It's by statute. That's not jurisdiction. That's the law that you're being charged under is not common law. It's a statute. It's an ordinance from the city of Romulus. Now, if you want to know what that ordinance says, then you can get that ordinance.
I understand what you're trying to tell me, but I'm saying the Constitution, Fifth Amendment of the Constitution, have rights and expression. I'm just asking questions.
And I'm answering it to the best of my ability.
This all like, oh, it's you said it was criminal, guy. I know criminal as common law, and I know criminal as benevolent.
Okay, well, then your knowledge is not complete. I don't know what to tell you. You don't, you're swimming in a pond, you don't even know the rules. But you've chosen to do that. And I have a right to ignore your questions if I've answered them already, which I've done more than one time. So here's where we're at. This is a pretrial. Do you want to talk to the prosecutor today? Yes or no? Yes or no? Okay, then go talk to the prosecutor. And I have a right to ignore your questions. Yes, I'm under oath, but that has nothing to do with my ability to tell you, no, I'm not answering any more questions. Go talk to the prosecutor. That's what a pretrial is for.
On prosecutors waiting list.
I don't know if we want to create a file for it. No, that's what I mean.
If you speak to the prosecutor, that knows their side of the meeting.
I'm not, I just don't want nobody to be liable. That's all.
Okay, let's talk to the prosecutor about that.
Now that right there, that's a textbook example of a sovereign citizen spiral. The defendant keeps talking about common law, but what Judge Oakley is trying to explain is critical. This case falls under city ordinance, not ancient or self-invented laws. Sovereign citizens often argue they're not bound by statutes, but courts have rejected that logic again and again. Oakley's tone here, calm but firm, is strategic. He knows engaging too much gives them control of the room, so instead, he cuts straight to the core. You're swimming in a pond, you don't even know the rules. That line alone sums up the entire dynamic. The defendant is lost in legal jargon, and Oakley's reminding him this is his courtroom, not a YouTube debate.
All right, I'm ready on Miss Maggie. How do you pronounce her name?
McGee.
Oh,
McGee.
that's what I kept saying wrong. That's
All
how
fell apart. That's how we got
that's
here.
why. Oh, well, let's make sure. Yeah, okay. Let's make sure it don't fall apart today. Because she's supposed to be in person. Miss McGee, start your camera. Okay. All right. Oh. This is case number 224518101, the people of the state of Michigan versus Adriana Renissa McGee. Defendant is charged with 1 count of disorderly disturbance, and today is the date set. Adjourned sentencing. And appearances, please, even though I said Ms. McGee had to come in person. Appearances, please.
Good morning, Your Honor. Delisha Coleman on behalf of City of Detroit.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Adriana McGee. Ms. McGee, ma'am, will you please say your first, your middle, and your last names?
Adriana Renissa McGee.
It was at 8:59, so I didn't do a pre-sentence investigation for Ms. McGee, but we were here the other day.
Now let's switch gears, because this next case? Oh, it gets spicy. Judge Lennis Bryant runs a tight courtroom. Her expectations are clear: show up, show respect, and follow instructions. But the defendant, Miss Adriana McGee, is about to challenge that. The setup is already tense. Bryant recalls a prior hearing where McGee got smart with the court, and right away, we can feel this judge isn't about to relive that headache. This moment perfectly highlights the fine line between courtroom composure and contempt. If you've ever wondered how tone and attitude can make or break your standing in front of a judge, keep your eyes on what happens next.
And I mispronounced Miss McGee's name, and Miss McGee got real smart with the court, and it went real left. And then I said she had to come in person that day, and then by the time she got here, I was not here anymore, and then I had her to be interviewed by the specialty court, and I understand that she was interviewed by the specialty court, and that she does qualify for the behavioral health court. So with that in mind, with respect to sentencing, is there anything on behalf of the people?
No, thank you, Your Honor.
I was trying to request a new attorney though.
Ma'am, okay.
They told me I came
With
down
that
to the
in
court
mind, Ms.
yesterday.
McGee, it's getting ready to go. This is why I said she had to come in person.
I did come in person. I came the day you
This
told me
is
to
why
come.
I said she had to come in person. And I
They
was
said
talking
it was
to
a
Ms.
virtual
McGee,
hearing.
because if I was talking to Ms. McGee, I wouldn't have said she. If I was speaking at that moment to Ms. McGee, then I wouldn't have said she. I would have said you. But since I wasn't speaking to Ms. McGee, that's why I said she. And then I just gave a speech and I said that Ms. McGee came in person that day and spoke to specialty court. And so if I was talking about that Ms. McGee had to come in person that day, I would have said that she came in person and therefore she fulfilled my requirement for coming in person. But since I wasn't speaking to Ms. McGee and I wasn't speaking about the requirement to come in person the other day, but my requirement that she come in person also today, that's why I said what I said. And since I said what I said, and I said it the other day, and I see that this is getting ready to go south again, I'm gonna again
I'm
require
listening
that
to
Ms.
what you have
McGee
to say. I'm
is gonna
receiving.
come in person, and she's not gonna overtalk me because I am not gonna be overtalked.
Here it is, the tension snapping in real time. Judge Bryant makes it crystal clear she won't be overtalked. Notice how she takes control of the narrative immediately. She's not just maintaining order, she's defending the authority of the court itself. In legal settings, respect isn't optional, it's procedural. When McGee interrupts or pushes back, Bryant's response isn't personal, it's about upholding the chain of command. That's why she sends McGee to the breakout room, not as punishment, but as a cooling-off strategy. Judges often use these virtual timeouts to prevent contempt situations. It's firm, fair, and strategic. Bryant knows when to enforce the line before it crosses into chaos.
It's just not gonna happen. So let's do this. I know that specialty court gave her a day to come in person, and then I think she said she was, when she just blurted out in my courtroom just now, and didn't wait for me to acknowledge her to speak, she said she was gonna request another lawyer. And Ms. Stevenson, are you aware of Ms. McGee's request that misdemeanor and felony defender be removed from the case? Were you aware of that before now?
Not until this very moment, Your Honor. I would say that we are at sentencing at this point. And if the court were to follow the recommendation of specialty court, that Ms. McGee would have another lawyer provided to her when she starts working with the specialty court.
Yeah, I know. You said that for her benefit, not mine.
Yes, Judge.
Oh, I know. Okay. So what I'm going to do is send Miss McGee back into the breakout room. I'm going to allow her to speak to you, Ms. Stevenson, regarding her request for new counsel. And I'm going to allow you to explain to Ms. McGee or to allow her to ask questions about what you just said on my record that was really for her benefit. And then I'll decide if I'm going to hear the case on Zoom. Because I did, in fact, say I wasn't hearing her cases on Zoom. I wasn't going to hear her case on Zoom.
Oh, yes, sure.
For very reason. So she go back and you all can discuss her request, and then we can move forward. So I'm going to put her in put Miss McGee in breakout room number 3. You can please accept to join that breakout room, and then we can go from there.
Okay. Thank you very much.
Who interviewed Miss McGee? Did Miss Warfield interview Miss McGee?
I don't think so.
Mr.
I don't think
Flanagan,
that's what
I
Sarah.
want Miss Warfield to come in and talk to Miss McGee, please.
Yes.
Okay. That's who I want to talk to, Miss McGee. Please find Miss Warfield.
What a ride. 2 courtrooms, 2 completely different energy levels, but one clear message. Judges run their courtrooms, not the other way around. Judge Oakley showed us how to dismantle pseudo-legal confusion with calm authority, while Judge Bryant reminded us that confidence without respect will always backfire in front of the bench. Cases like these show the delicate balance between maintaining courtroom control and allowing people to speak their truth, but it's all about how they do it. So, what do you think? Was Judge Bryant too harsh, or just doing her job? Drop your thoughts below. We love hearing your takes. And if you found this breakdown as wild as we did, hit that like button, share this video, and subscribe for more jaw-dropping courtroom moments. This is Carl from So Saitais Chronicles. See you in the next one.